Okay, thank you, Julia. I'll go ahead and talk about the effect of COVID on family-based immigration cases. Before I get to the family-based, I want to touch a little bit about both family-based visas and employment-based visas. The Immigration and Nationality Act, INA, allocates each fiscal year immigrant visas for both employment and family-based. For employment, it's around 140,000, and for families, around 226,000. And out of those, each country receives no more than 7% of those allocated visas. Because of COVID, a lot of those visas are not being used, especially family-based visas. Family-based visas are usually processed at the consular office or embassies. And because of COVID, those processes are not available since most of the consulates are closed. So we are seeing a lot of those visas not being used. And the INA also states that any unused allocated category of visas can be rolled from employment to family, from family to employment. So in the fiscal year for 2021, we did see a lot of employment-based visas that rolled over from the family-based unused employment-based visas. They rolled over, so there was more employment-based visas available than ever before. So as you see in October, which is when the fiscal year starts, there was a lot of unprecedented 485s that were filed. So we're also expecting the same to take place in fiscal year 2022, because as COVID continues in other countries, as previously stated, we're not seeing the consulates adjudicate any family-based cases, or there's delays, and they're not being used. So all those unused visas will be rolled back to the family ones to employment. So we're expecting in fiscal year 2022, meaning October 22, there will at least be 275,000 visas. That would mean that would probably move the data filing for countries like India, China to unprecedented levels. So there will be another, 485 quota, as we call it, meaning there's tons of cases being filed in October. So let's go ahead and talk about 485s. Okay, 485s is an adjustment of status. So adjustment of status is just filing a green card while you are in the United States. A requirement is that you have to be in the United States and maintaining status to file a 485 application. If you are in the US and maintaining status, ILBSG does recommend filing a 485 instead of going through the consular processing, just because, as I stated, they're not open for processing. When you are filing a 485, we did see, and we do continue to see, a lot of delays for receipt notices confirming that USCIS has accepted your application, just because of the numerous petitions that USCIS is receiving, and because of, I'm sure, the limitation of people that are working for USCIS. So it may take 60 days or more. We are seeing those delays that are actually taking more like 3 months. But that is continuing to get better as USCIS is learning how to handle those high volume petitions. The good thing about COVID that brought on one change in filing 485s is back in 2017, USCIS decided for all employment-based cases and family-based cases, they're going to have interviews. That has been waived for most employment-based cases. So they're just going ahead and giving green cards with straight approvals, just to reduce the backlog that they do have. For family-based cases, meaning filing I-130, a relationship with either a U.S. citizen or a green card holder, we are seeing the interviews, but delays do persist. So if you have those pending applications, just be patient and continue to monitor what your field office is doing, and if it's outside of normal processing time, placing a service request. Generally, that's been the process for 485 applications. Moving on to I-130s. I-130s are a petition for an alien relative. So this is usually filed by a US citizen, for a spouse, a parent, or a child, or a green card holder for the same categories. We are seeing a lot of process delays by USCIS in adjudicating these cases. Also, once approved, it moves to the National Visa Center processing. We are also seeing a lot of delays on that. Unfortunately, most consulates are not open to process these cases. Once NVC has confirmed they have received all the requirement documents, they do forward that to the embassies. And since embassies are only doing high priority cases, emergency visas, or they may not even be open, depending on the location of the country. So that we are seeing a lot of delays in that case. They did give high priority to immediate relatives of US citizens, meaning spouses and parents and children under 21 years old of US citizens, and other family-sponsored applicants. But as we said, that is if they are open and they are processing those cases. So if they're not open, if they're only open for emergency-based cases, we're not seeing them process any of these. Okay, so fiancé visas or K1. Similar to I-130s and 45s, we are seeing process delays. They're taking approximately 6 to 9 months. On average, it's 7 months. It used to be much shorter than that before COVID, but unfortunately, we are seeing the delays. Again, we're seeing another delay at the National Visa Center, although Praveen earlier mentioned those who have K1 visas may travel to the United States. Actually getting those visas is an obstacle because usually the consulates are not open to processing these visas. So K1 processing is suspended for most places. They do place them as priorities if the consulate is open. So in any of these cases that I mentioned, we recommend checking with the consulate, see if they're processing any of these visas. And if there's an emergency, you may always, of course, reach out to us or the consulate and seeing how we can help you. Okay, so let's move on to naturalization applications. Naturalization applications are, an applicant seeking to become a US citizen. We're also seeing a delay on that front because USCIS needs to take biometrics, interview, and then eventually an oath ceremony. So that requires 3 contacts with the USCIS office. So USCIS has started processing these cases, has started doing biometrics and interviews, but unfortunately, because there was a year where they weren't processing these cases, there is a lot of delays, but we are seeing them reschedule and process these cases. But again, you have to check your field office depending on the volume of number of cases that each field office has. One can be faster than the other. For example, Chicago may be delayed because there are more applicants filing in Chicago than in Iowa, for example.
Right.
Yeah. So it's just delay, but being patient and understanding and planning for it will be good. B2 and B1 related considerations. So we're seeing a lot of people ask questions in regards to B2, B1. There are a lot of people that traveled probably February 2020 or March 2020 before the COVID pandemic hit that were here on a B2, B1 visa. Usually B1 and B2 are granted for 6 months. And then before that 6 months is up, you're allowed to ask USCIS for an extension for up to 6 months. But that 6 month probably, if you came on February 2020, that 6 months extension probably has come and gone, and now you're here more than 1 year, which generally you're not allowed to be here on a B1 or a B2 visa for more than 1 year. But COVID has presented, a different situation. USCIS was alerted in April 2020. If you are not able to travel, you can go ahead and file an extension. The important thing is to file an extension before your pending or your I-94 expires.
Right.
This is very key point. I would say with filing these, you also should gather some letter or in your statement of purpose or a doctor's note saying why your situation is unique and why you are not permitted to travel, like a doctor note saying, hey, I have a medical condition. If I'm forced to travel, I will contract COVID and that will be fatal to me or something like that. Or if your home country has
an ongoing pandemic situation.
Yeah,
so
like
which
India right now.
Yeah.
So I would recommend doing that. But the point right here is to make sure you file it before your I-94 expires or the pending requested time has expired. Okay. So F1 related. Just like everything else, what Julia was saying for F1 applications, we do recommend filing it within the United States, filing a change of status using the Form 539. We do not recommend, like previously, that you step out, go through the consular processing to get a F1 visa, just because, one, you don't know if you'll be able to come in if you're from the countries that Praveen has mentioned, or if the consulate is open to process those visas. Even with filing 539 form with USCIS inside of the United States, that we're seeing a long delay. We're seeing over 1 year. As I'm sure most of you know, having an F1 pending, unlike other petitions, doesn't guarantee you or give you permission to stay in the United States. So you will need to have another application that's also pending concurrently if you don't have any other status to allow you to stay here. This is called a bridge application. So for example, if you're here on H4 and you're aging out, you need to file, while your F1 is pending, you need to have a B2 pending to make sure that you are here staying legally.
Makes sense.
Yeah. So it's very important to know that just having a pending F1 will not
itself is not a status.
Yeah, will not afford you any protection. And if you just have that, you will still be an unauthorized period.
Okay.
And for those who have F1 visas, the question was early on, can I take online classes? Can I do it in person? In most classes, most universities transition to online classes, but the INA doesn't usually allow F1 students to be permanently or exclusively on online classes. So the USCIS and ICE have said if you are an F1 student holding an F1 visa on March 9th, 2020, you may continue taking online, hybrid, or in-person classes in any combination. You will be maintaining your status for the fiscal year 2022 or the academic year of 2022. If you are an F1 student who entered after March 9, 2020, you should at least take one in-person course, so that you have to check when you're using your F1 visa. If you're coming in, you have to check what your school is doing. If your school is only exclusively doing online classes, so you will not be able to get in with that F1 visa. So as I said, newer initial F1 and M1 students who previously have not enrolled by March 9th, 2020, it's very important to check with your school and see what type of curriculum they have to make sure that you are abiding by the rules.
I think the right thing for them to do it is to get in touch with the DSO, the international office of the school, and get the guidelines which are applicable to them, because this is a different scenario for each student. I think they should be relying more on the DSO because they have the latest guidelines, and also at the same time, probably each school has a different program, and that might offer different things, different options for you.
Yeah, exactly. And then they also need to update your civis, so it's very important to always keep in touch with your DSO.
Got it.
Yeah. Okay. And then another hot topic that a lot of people have questions on are green card holders that are stuck outside of the United States because of COVID. Either they don't feel safe to travel, or they're not allowed to come in. So if generally, if you're outside of the United States for over a year, your green card is not a valid reentry permit, meaning it's not a valid documentation that you can use to enter. So in these type of cases, the first and best thing that we do recommend is applying for what's called a SB1, a returning visa. At the consulate, if they're open, do it as soon as possible. And each consulate has different processes in applying this, so you need to go contact them and see what each what their process is specifically. The option two, and the more riskier option, is if your green card hasn't expired, you can travel directly to the US and assert at the port of entry when you're being checked in that you never meant to abandon your green card status because of COVID. You weren't able to come in. You can have canceled flight tickets or other documentation showing you never intended to abandon your status, but unfortunately, because of a global pandemic, you weren't able to come in.
Which I would not personally do it if I'm into that situation. I would rather go through SB1 because that's more secure way of traveling, because you don't want to travel for 18 hours, 24 hours, then get stuck here. So
yeah. So, and then in cases where your green card has expired, we would definitely recommend in that case to go ahead and apply for SB1 visa at the consulate and see if they will give you that visa to come in. That's our best recommendation. And then again, there are some places where the consulate are not open. Although we don't recommend it, if there's some emergency situation, you might try to come in and appeal to the CBP at the port, right, with documentation. So you should have strong documentations showing that you never meant to abandon your permanent residency. And we do help with that type of applying for that type of visa. And even if you do want to just come in at the port of entry, you can consult with us and we can recommend what type of documentations that you should carry with you when you're coming in.
I think we can go over to Durti for any questions. I think we are